The legal fallout of mortgage fraud, a case study of the New York Attorney General. What happens when a top law enforcement official commits mortgage fraud? The damage may outlive the statute of limitations, because the title to the property may remain poisoned forever. In this video, we uncover the legal ripple effect of one fraudulent signature and how it can destroy property rights, public trust, and the rule of law. 1. Introduction: Why mortgage fraud never truly dies. Mortgage fraud is not just a breach of trust. It creates a permanent defect in the legal structure of property ownership. Even if the fraud occurred years ago, the consequences linger indefinitely, especially when public officials are involved. 2. Statute of limitations: What it covers and what it doesn't. In New York, criminal mortgage fraud, 5 years under CPL Section 30.10(2)(b). Civil fraud, 6 years from the act or 2 years from discovery, under CPLR Section 213(8). Federal bank fraud, 10 years under 18 U.S. Code Section 3293. However, these statutes apply to people, not property. The statute of limitations can bar prosecution, but it does not erase the consequences of a fraudulent filing on a property's title. 3. Fraud and title defects: Why the clock doesn't matter. A fraudulent mortgage, signed with forged names, invalid power of attorney, or misrepresentation, creates a clouded title. This defect does not expire. It stays with the land until it is corrected through litigation or re-recording. The marketability of title, the issuance of title insurance, and the legality of any future transfer may be compromised. 4. Public officials and fraud: Immunity does not apply. If the Attorney General of New York signed a mortgage document fraudulently, no amount of official immunity will shield them from liability. Fraud is considered an ultra vires act, outside the scope of lawful authority. Qualified immunity does not cover intentional misconduct. 5. Legal ramifications for future buyers. Even if the fraud occurred a decade ago, a new buyer attempting to purchase the property could be denied title insurance, be unable to finance or resell, inherit unresolved litigation risks, or face quiet title actions by third parties with competing claims. 6. Permanent injury to the public record. Recording a fraudulent instrument in the county recorder's office is not just a private wrongdoing. It undermines the reliability of public land records. The harm is systemic. Every subsequent transaction relying on that record is poisoned by the original fraud. 7. Conclusion: The legal legacy of a single act of fraud. Even if the Attorney General is beyond criminal reach, the consequences of their fraudulent act are not extinguished. The title remains clouded, the public trust is eroded, and the law retains the power to void, challenge, or correct what was falsely recorded. Footnote: In property law, fraud affecting title is a defect in rem, not merely in personam. Its legal consequences attach to the asset, not just the actor.